Good morning. Welcome to this presentation, this idea to IPO presentation on H-1B visas, U.S. visa options for international tech professionals, entrepreneurs, and investors. My name is Chad Graham from the law firm of Graham Adair. I'll take a second to introduce myself on the next slide, but first I want to say a few things. One, this video is being recorded. We will make this video available to all attendees after this meeting. We will also make these slides available, so don't feel like you need to take notes and write down everything here. We'll go ahead and make those slides available to you. If you have questions, please put those in the chat. This presentation is designed to go for 1 hour, followed by 30 minutes of question and answer. So I will go through the presentation, and then at the end, I will look in the chat and answer questions at that time. So with that, please feel free to think of questions that you have and ask those. I'll be happy to do that. If you raise your hand, I won't see you, so just put those in the chat. Okay, with that, let me go ahead and introduce myself. My name is Chad Graham. As I said, I'm from the law firm of Graham Adair. We are based primarily in San Jose, California, and in Austin, Texas. We have clients all over the world, really, all parts of the United States and in many countries. I have been practicing immigration law for 16 years. We work primarily with corporations and individuals through the employment-based immigration process. So if your plan is to come to the United States to get work, that's where we come in and we can help you with that. Just to introduce my firm a little bit further, we really are focused on the client experience. And so I'm bragging here a little bit on this slide. We have Google reviews, over 100 Google reviews at 5 stars. And the reason for that is we really do focus on that experience for each of the people that we work with to make sure that they understand what the process looks like, answer questions, and kind of hold your hand as we go through the process. It can feel daunting to go through this process. There's a lot of paperwork that's required. We're dealing with, of course, the US government. And so ensuring that we have everything done properly is very critical. So we walk through that with you and we focus on that experience for you. Now, as far as the agenda goes, as the title indicated, we're going to focus a little bit on the H-1B. So we'll talk about what the H-1B visa is. Then we'll talk about the lottery, the H-1B lottery, and how that works. The reason that this presentation is focused on that is because this is what we call the H-1B cap season. So if you're interested in an H-1B, now is the time to be looking at that and considering this as an option for yourself. There's a limited number of new H-1Bs available every year, and the process for applying for those visas is coming up right now. So we're in the preparation period for H-1B. After that, we'll talk about some other options, some other visa options. So F1 for students, L1 for intra-company transferees, O1 for those with extraordinary ability, the J1 cultural exchange visa, E2, which is an investor visa option. And then we will talk about what we call some immigrant visa options, or this is commonly known as the green card process. And that will be the national interest waiver and then EB1 for extraordinary ability. The reason we're focused on those two is because they are self-petition options. They don't require, most visa options require sponsorship from an employer, from a US employer, but there are some options that are available to you without having an offer of employment from a US-based company. So we'll talk about those things. Okay, so let's start with the non-immigrant visa options. The reason these are called the non-immigrant visa options, or sometimes work visas, is because they give you the ability to come to the United States and work, but they don't give you lawful permanent residency. That's not to say that you can't eventually apply for lawful permanent residency, Many of these visas do allow for that, but they're considered non-immigrant, meaning they don't give you immigrant status in the United States. Okay, so first let's talk about what the H-1B is, and then then we'll go into the H-1B lottery and how that annual limit works. So the H-1B is considered a specialty occupation visa. So it's a visa for people typically who are in the professional types of positions that require at least a bachelor's degree. This doesn't need to be a US degree. You can have a degree in your home country, and then what we would need to do is get an equivalency done to be sure that it is equivalent to a US bachelor's degree. And in nearly every country, works out just fine. Once in a while, we have a situation where a bachelor's degree was granted with fewer credits than are necessary in the United States. And so in those situations, we may have a little bit of difficulty getting the equivalency, but we work with an agency that's really good. They can add experience that you have in the field and often get to that bachelor's degree equivalency. Obviously, if you have higher than a bachelor's degree, that's great as well. The H-1B is employer specific, so you would have to have an offer from a US company in the United States who is willing to sponsor you for the H-1B. This is not a self-petition option. As I mentioned earlier, there's a limited annual cap of 85,000 new H-1Bs available every year. This limit has been in place for, I think it's 15 years now. Demand has gone well above that 85,000. So what happens is, because there are so many people that are interested in the H-1B, but there's a limited number, what the government does is it runs a lottery. So everybody submits, their intent to apply for an H-1B. The government runs a lottery. It's the U.S. Citizenship and Immigration Service, or USCIS, that runs the lottery. Those who are successful are then enabled to file the paperwork necessary for the H-1B. That 85,000 is broken down as 65,000 under what they call the regular H-1B cap. And then there's an additional 20,000 for those who have an advanced US degree. So if you're in the United States and you're getting a master's degree or a PhD or some sort of higher level degree, then you qualify for this set aside of 20,000. And often that's worth it, because the way the lottery runs is they'll run a lottery for those 20,000 first. And then after that, anybody who's unsuccessful goes into the regular lottery of 65,000 and has another chance of being selected. So those with advanced US degrees overall have a higher chance of being selected in the H-1B lottery. The process is the timing, and I have a slide on the timing that I'll show you in just a minute, but in March is when the lottery is run. So that's why we're looking at this now, because people that are interested need to get registered and ready to be entered into the lottery, which will happen in March. Then if you're selected, your new H-1B will start at the beginning of the government's fiscal year, which is October 1st of 2024. And a couple other things I wanted to mention about the H-1B. If you are an employer and you're looking to sponsor a candidate for an H-1B, one thing to be aware of is that there are certain attestations that the employer must make. And one of those is that they will pay what is called the prevailing wage. So what the government does is it goes out to each geography and within each industry and figures out what the salary should be for people, sort of like a median or mid-range salary, and there's different levels. And then if an employer is sponsoring a candidate from another country for an H-1B, they need to pay at least that minimum amount of salary. The idea behind that is to ensure that companies aren't bringing in people and paying them cheap labor or giving them different working conditions than they are for their US counterparts. So it's a way to sort of level that playing field for everybody. An H-1B is valid for 3 years and then can be extended for an additional 3 years, so 6 years total. However, if most companies, if they're going to sponsor somebody for an H-1B, their intention is to also sponsor them, assuming the employment goes well, eventually sponsor them for a green card. And so if you have an H-1B and your company sponsors you for a green card, then you can extend that H-1B really indefinitely until you get your green card. And this is important for people from certain countries where it takes a long time to get a green card. For example, people from India, it can take, 10, 15 years before they can actually get a green card. And I'll show you why that is a little later in this presentation. But being able to extend that H-1B indefinitely is one of the most valuable reasons people go look at H-1B as an option. The processing time for an H-1B right now under regular processing is anywhere from 6 to 12 months. So it's a pretty long process. There is an option for premium processing, which means that if you pay an extra government fee, it's right now $2,500. So it's pretty expensive, but they will get a decision back within 15 calendar days. That decision can be an approval, it can be a denial, or it can be a request for additional evidence. But filing with premium processing does help the case to get through the process much quicker. One of the questions that comes up is if somebody already has an H-1B and they want to transfer to my company, let's say, how do I do that? Because their H-1B is tied to their employer. Well, what my company would need to do is file an H-1B transfer their H-1B to my company. And the nice thing about that is if somebody already has an H-1B, they don't need to be counted toward that annual limit again. They've already been counted, and so they're free to transfer. And that's another nice feature about the H-1B is it's fairly open for people to be able to advance in their careers, to change companies. And so the H-1B is very flexible in that way. And then as far as dual intent, so what dual intent means, and I kind of alluded to this a little earlier, it means that you can be in a non-immigrant status like H-1B while also intending to immigrate to the United States or to get lawful permanent residency. And so with an H-1B, that's okay. There are other statuses that I'm going to talk about, and I'll tell you which ones they are, where that's not allowed, where it is a pure non-immigrant intent status, and the ability to change from that status to a lawful permanent residency or a green card is limited. But for an H-1B, it's not limited. Okay, so let's talk about the lottery process here and what that looks like. So in terms of the preparation, it used to be that in order to be included in the lottery, a company had to prepare all the paperwork, have all of the signatures, all the documentation, the filing fee checks and everything, and they had to send that in to the U.S. Citizenship and Immigration Services. And these petitions are, an inch thick or something like that. So each case is fairly cumbersome to file. And if a company was sponsoring, say, 100 people, that was a fairly involved process to do that. And then what would happen is the government would get all of these applications, these physical applications, they would run the lottery. Anybody who was successful, they would take those applications and begin to adjudicate them and make decisions on them. Anybody who was not selected in the lottery, those cases were mailed back in the mail, and there would be a cover sheet on top saying you were not successfully selected in the lottery. So it was a cumbersome and time-consuming process, but it was a very straightforward process as well. Well, a few years ago, the U.S. Citizenship and Immigration Service changed to an electronic registration process, which is fantastic for a number of reasons, but it also includes a number of pitfalls. So we always applaud the government when they try to innovate and use technology to make the process better. So I think it's great that they're doing this, but there are simply some things to be aware of when you do this. So now the way the process works is the company must be registered ahead of time, and they must get an approval to say, okay, you're now authorized to register people for the H-1B lottery. Once they get that authorization, they can then begin to add individuals, whether it's one or whether it's 100 or 1,000 individuals that they wish to register for the H-1B lottery that year. So that's the process we're in right now. We're getting our clients set up in the system and then starting to add individuals within their registration so that when the lottery is run at the end of March, those individuals will be considered for the lottery. Once somebody is entered correctly in the system, they will get a lottery number. This is one of the pitfalls with the system is if you put an individual in, but you don't put all of the correct information, or maybe you miss a field or you have something put in the wrong way. Maybe you have a dash and you're missing a number or something like that. The system doesn't come back and say, you need to add more information here. This person's not going to be considered. They just simply won't be included in the lottery. So that's where you have to be careful and go back and look at each person after they're registered, make sure that they do have a lottery number assigned to them. And then you can know for sure that they're going to be included that year. At the end of March, the lottery will run. The people that are in the system, it will show their status as either submitted or selected. So instead of in the past where you would get something from the government saying, yes, you were selected this year, or no, you were not selected this year, the only way to really tell is to look in the system to see whether the status still shows as submitted, which means they were not selected, or whether they were selected and their status changes to selected. If the person is selected in the lottery, there's a 90-day window to actually file the petition. So that's where you need to get all the paperwork signed, have all of the supporting documentation included, all the filing fee checks and everything like that, and submit that. Now, we got an exciting announcement last week from USCIS saying that they're going to allow for electronic submission of petitions this year. So this is a brand new thing where we're not going to have to actually mail in the physical application. So it will be a much more streamlined process. The details on how that's going to be done have not been released, so I can't walk you through exactly how that works yet. But that is exciting news. I think it'll make the process faster because, believe it or not, that 90-day window comes and goes pretty quickly, especially for companies that are sponsoring many individuals. Getting all of those applications ready and filed within that 90-day window can be difficult. So being able to do that electronically will certainly help. Okay, so now how did the selections work? Last year, interestingly enough, in the first round of the lottery, USCIS selected 110,791 total applications for the 85,000, which is strange because it's well above the limit. So why did they do that? Well, they do that in anticipation of having duplicates with cases withdrawn and then eventually denials. So what they're trying to do is anticipate all of that. And once the dust settles, they want to be as close to that 85,000 limit as possible. So duplicates have become a very interesting phenomenon, and I'm going to show you, I have a slide to show you kind of what this looks like after this, but last year there were over 400,000 duplicates. And so what happened is, even though USCIS accepted, about 25,000 more applications than the 85,000 limit, they were still well below the threshold because of all of those duplicates. So they actually ran a second round lottery and selected 77,600 additional cases. So people who in the system, where their status still said submitted instead of selected, a lot of those actually were selected in the second round. So we tell people, if they're not selected in the first round, don't despair completely. We do need to look at alternatives, but it's possible that you could be selected in the second round. So let me talk for a minute about what duplicates are. Duplicates is where a company, so the type of duplicate that has never been allowed is where a company sponsors an individual more than one time for the lottery. That's an unfair advantage. USCIS will look at that and they will disallow all applications for that individual if it's that type of duplicate. The types of duplicates that have been allowed in the past is where an individual goes to, let's say, 4 different companies. Each of those companies say, yes, we want to hire you, and we will register you for the H1-B lottery this year. Well, that individual would have a significant advantage over somebody who has just one lottery application through one company, because that person would be 4 times more likely because of the 4 companies that are sponsoring them. So, and that's what happened this last year with the over 400,000 duplicates is people got wise to this and figured out that they could get more companies to sponsor them and increase their chances of being selected. So there were so many duplicates. and it really kind of gummed up the process. And so what USCIS is going to do this year is they're going to tie a person's registration to them as an individual. So they could have 20 companies apply for them and they will still only be counted once for the lottery. And so that, and the goal there is to get rid of these duplicates that we've had in the past and make the process much more predictable and fair for everyone. So here's a chart I was talking about. The blue line there is the total registrations, meaning the total number of people applying for the H-1B lottery. So you can see the data that I have starting in 2014, it was just over 100,000. And then it kind of climbed up to over 200,000 and stayed fairly steady. And then all of a sudden in 2022, it really had this exponential increase. And that's where, if you look at the gray line, that's the number of duplicates that were filed as well. And you see as that gray line increases like that, the number of registrations goes up. So that's really the issue that we had. And then the orange or red line there is the number of selections. So the number of selections have stayed pretty steady. The U.S. Citizenship and Immigration Service selects more than the 85,000, again, to try to account for the duplicates, withdrawals, and denials. They tried, you can see last year, they tried to select more, in anticipation of the duplicates, but they just had no idea just how many there were going to be. So this year, tying that lottery selection to the individual should really help with making it a fair process for everyone. Now, in terms of the timeline, as I said, we're in the H-1B process right now. We call it the H-1B season, where we're getting companies registered, we're getting individuals placed under those companies to be included in the lottery. That's happening right now. At the end of March, so during March, the registrations will be added to the system, and at the end of March, the lottery will actually run. As I said before, they'll run the advanced U.S. degree cap first, those 20,000. Anybody unsuccessful there will go into the regular lottery. And then those who are selected will have a 90-day window from April to June to actually file the cases. As I said earlier, we'll be able to do that electronically this year. That'll be an option. And then sometime during July or October, if USCIS needs to, they will run a second lottery. And then for those whose cases are approved on October 1st, which is the beginning of the government's new fiscal year, those new H-1Bs will become active. Okay, so before we get into alternatives to the H-1B, I want to remind everybody that this presentation is being recorded and the slides will be provided to you at the end of the presentation. As you have questions, please put those in the chat. This presentation is designed to go until 9 a.m. Pacific time, and then from 9 to 9:30, I will answer questions in the chat. Okay, so for people that are not selected in the lottery, a lot of times the question is, well, what do I do now? Do I have to leave the United States? Or if I'm outside of the United States, am I out of luck and I don't have any more options? The answer is probably no. There are alternatives to the H-1B, and so I want to talk about what those are right now. One of the main ways people come to the United States is as a student. So they find a U.S. college or university, they enroll, they apply, and then enroll in the university, and then the university will sponsor them for F1 status as a student. The nice thing about F1 status is it enables you to go to school and to study your profession that you're looking to go into, but at the same time, it also can provide for work authorization. And so one of the main ones that you'll hear about is optional practical training, and this, or OPT, and this is really designed for people who are graduating at the end of their, once they earn their degree, then they're given 1 year of time to be able to work in their profession. So they'll need to apply to USCIS. They'll receive an EAD card, employment authorization document, and that will enable them to go to a U.S. company and to be able to work for up to 12 months. Now, for anybody who is in a STEM degree, science, technology, engineering, or mathematics, they can get an additional 24 months, so up to 3 years total of work authorization. And so this is something that a lot of people are doing is they come to the United States, they earn a degree, and then they get up to 3 years of work authorization post-graduation. And during that time, their company will try to get an H1B for them. So, and the nice thing about this is that they're unsuccessful the first time, they have a second opportunity and potentially even a third opportunity to get an H1B. So most people who come here as F1 students and get a STEM degree and they have those 3 years of work authorization, most people are able to get an H1B and to be able to stay in the United States long term. For people, sometimes people ask the question, well, if I don't get an H1B during those 3 years, can I just do another academic program and get an additional 3 years? The answer is yes, as long as you're getting a higher degree. So if your first degree was a bachelor's degree and then you re-enroll and you go for a master's degree, then yes, you can qualify for an additional 3 years. If you decided to do another bachelor's degree, the answer is no, you would not be able to get an additional 3 years or 1 to 3 years of OPT time. The other nice thing about being an F1 student is while you're going to school, you can get work authorization, part-time work authorization called curricular practical training or CPT. So a lot of times people come here, and most universities won't grant this during the first semester or even year of your program, but during the second year, you can often get this curricular practical training. So if you're going to school to be an engineer, let's say software engineering, then while you're going to school, you can get a part-time job doing something in that field. It needs to be in the field of your study. So you would need to get a job in some sort of software engineering or related field, and then you could work part-time under CPT. It does not require application with USCIS. The nice thing about CPT is the school grants that directly to you. So it's a fairly straightforward process. They just need to verify the employment and who the employer is going to be, what you're going to be doing. One thing to be, a couple of things to be aware of. One is some universities will give you full-time CPT, so you can actually work full-time while you're going to school. The thing to be aware of is, and this is something to talk with the International Student Office about, is whether that will count against your OPT time when you graduate. Because for some universities it can. So let's say you do 6 months of full-time CPT, then you would only be eligible for 6 months of OPT when you graduate. The other thing to be aware of are day one CPT universities. So there are some universities out there, these are typically the for-profit universities where they're charging a tuition and generating revenue, or they will promise you that they will give you work authorization on day one. And some of these universities are not properly authenticated. And so it can be a problem for your immigration status going forward if for some reason the certification of that university is later pulled. It can look like your immigration process can be in jeopardy. So I would just say if it's something you're looking at, it's worth talking with an attorney to be sure that it's something that might not come back to bite you down the road. Okay, so the next option here, and this is a good option for a lot of people who are outside of the United States currently, not currently in the United States, or if you have a company outside of the United States, looking at an L1 can be a really good option for you. L1 is called an intra-company transfer. So it's for people who have worked for a company outside of the United States for at least 12 months, and now they're transferring to an affiliated entity of that company inside the United States. The person transferring must be a manager or executive of the company, or if they're not, then they need to have specialized knowledge. So for people who are managers or executives, this is an L1A. The nice thing about an L1A is that it is valid for 7 years total, whereas an L1B for specialized knowledge is valid for up to 5 years. But otherwise, they function very similarly in terms of the work authorization that you're granted in the United States. Those who are considered managers or executives is sometimes a question. If you have direct reports that are not what are considered frontline workers, but let's say other degreed professionals, then that's a very straightforward definition of an L1A executive or manager. If you don't have direct reports, you don't have anybody who reports to you, it's possible you can still qualify as what they call a functional manager, meaning that there's a function or a process within the company that's very critical to the company that you manage. It's likely that you would have a budget. Your reporting chain would be close to the highest levels of the company, things like that. It's a harder definition to achieve, but it is something that's possible. If you don't have direct reports, you may still be able to qualify for L1A if you manage an important function of the company. For L1B, specialized knowledge, these are other individuals who are not managers, they're not executives, but they do have a very special and specific knowledge of something that is not readily available in the United States. So sometimes this is something that's very specific to the company, like a tool or a process that company has that's proprietary, or it could be a skill that is unique and not readily available in the United States. So then what we do is we make the application and say this individual has these rare skills. That's why this company is transferring this person to the United States. Then they come here under specialized knowledge. Before I get to this, the nice thing about L1A is like H1B, it is considered a dual intent status, meaning you come here as a non-immigrant. L1 status is a non-immigrant status, but then you can also apply for lawful permanent residency or a green card. So people come here on an L1, often they go through the green card process as well. Now, for those of you on this call who may have a company outside of the United States, but no operations within the United States, this can still be a really good option for you because there is something called a new office L1. And what this means is, let's say you have a company in India, it's operational, you've been doing it for 10 years, and you say, I'd like to expand to the United States. And maybe this is a way that you yourself want to come to the United States. So in your office in India, you would have people to continue running that, and you would say, I'm coming to the United States to set up the US office. We would apply for you a new office L1. And the way this works is USCIS is very likely on the initial application to approve it. But it's approved for 1 year. And the reason for that is they want to look at it again in 1 year to be sure that the US operation is viable, that this wasn't just sort of an end run to try to get somebody here without actually starting a viable US company. And so usually what we do is we provide a business plan and we say, these are the things that are going to happen. A lot of times what they want to see is that you're going to hire people in the United States, that you're going to create jobs. And so at the end of that year, if we can show, yes, they've hired 2 or 3 people, there are now revenues or there are agreements in place to begin to have revenues, then likely that extension will be approved and you will be able to stay in the United States on a long-term basis. Okay, the next option, the next non-immigrant option is O1 for extraordinary ability. This is an employer-sponsored application, so it's not a self-sponsor option. It requires a US company to sponsor you for this. And basically what we're showing is that you have risen to the top of your field, that you are nationally or internationally recognized for the work that you do. Typically, we see these applications being successful in the fields of science, education, business, or athletics. And that's not an exhaustive list. I'm just saying those are the ones that we usually see. But being able to show that you have achieved recognition, you've risen to the top of your field, people know who you are. These are the types of things that they're looking for. In order to prove this, there are 8 criteria available, and we need to prove at least 3. And I'll show you on the next slide what those criteria are specifically, but we need to show at least 3. If you can prove more, great. And then the other thing I want to mention here is that this is considered a quasi-dual intent status. The reason I call it quasi-dual intent is it's not specifically carved out as a dual intent status like H1-B and L1, but it really functions the same way. So if you qualify for an O1, chances are your path to a green card is a very straightforward path as well. Okay, so here, these are the 8 criteria. You can see them on the left side there, original contributions. So original contributions are things that you've done that no one else has done. So a patent is a very good example of this, because obviously if you're able to get a patent, then you've demonstrated objectively that you've done something, you've created something novel. One of the questions that comes up is, what if I have a patent that's pending but not yet approved? That's good evidence as well. Not as good as having an approved patent, but it still is pretty good evidence that you have a patent that is pending. Other examples of this, one thing we'll ask you to do is get letters from other people in the field that can talk about the things that you've done. If you've written white papers, that can be good evidence as well. And we're trying to show that you've done something that nobody else has done. That's original contributions. Publications and citations. So if you've published your work, especially in journals that have a high impact, high readership, and a high level of respect within the field, that's really great evidence. Sometimes the question is, well, how many articles do I need to have written? There's not a specific bright line number. I would say at least 7 or 8 is probably where you want to be. If you have less than that, it's possible that you can still qualify for this category, but we would need to show that the work has been cited many times, that you have a lot of citations. So if you've written articles, we would pull your Google Scholar profile and use that to prove this field. We would need copies of the articles. We would need copies of the citations. So this status requires a lot of documentation. I told you earlier that the H1Bs are about 1 inch thick. These ones are like, 4, 5, 6 inches thick with all of the documentation. The next one is articles written by others about your work. So a lot of times people look at this and say, well, I have 100 citations. Does that count? The answer is no. Those citations really go toward the previous criterion, which is your publications. This one is more about people who've written articles specifically about your work. They're not just citing it, but they're saying, a whole article about something that you've done. Major awards, this can be grants that you've received. It can be university awards, but these are the types of awards that are sort of, well known. So often, a company award or winning something within your company is not enough. It needs to be something that is sort of a lot more broad and well-known type of award. Memberships, we say restricted memberships because a lot of times people who are engineers will be members of IEEE, and by being an engineer, they qualify simply to be a member of IEEE. That in and of itself is typically not enough to satisfy that category. However, if somebody in IEEE is, let's say, on the editorial board or the selection committee or something like that, where they're invited or they have to qualify for that membership, then that can be good evidence of a restricted membership. So it's something where not anybody in the field can apply for. It's maybe invitation only, or it's restricted in some way, that it's considered sort of a more important membership than simply being a member of a profession. Being employed by an organization, a well-known organization. So if you've previously been employed by a publicly traded company, you were there for a number of years, and let's say you advanced and you got promotions and things like that, that's really good evidence for this criterion. Or if you've started a company or been one of the early members of a company, a startup company that did well, that can be good evidence as well. So they're looking for successful organizations and that you've been a part of that. commanding a high salary or remuneration. I mentioned earlier with the H-1B process how there are prevailing wages depending on the location and the industry. If your remuneration is at least 25% above that, then that can satisfy this category of receiving high remuneration. The idea there is that you're so important, the work that you've done is so good that companies are willing to pay you more than the average person in your field. And then the last one is the judge or the reviewer of the work of others. A lot of times we have people who have done peer reviews for articles and journal submissions. If you've done a lot of those, that can be good evidence. If you've done just a handful, it's probably not sufficient. The better evidence here is if you were on the selection committee for a journal, let's say, where you were sort of ultimately making the decision on what's going to get published, what's not going to get published, which poster presentations are going to be allowed to move forward, which are not. That is really what we're talking about here as the judge or the reviewer of the work of others. So in terms of duration, O1s are great because they're initially valid for 3 years. You can get 1-year extensions after that. But as I said earlier, typically somebody who qualifies for an O1 has a really solid path to a green card. So typically within those first 3 years, people are moving toward the green card and they don't need to do the extensions. But if you do, you can get them 1 year at a time. The processing time for O1s is much faster than the other types of cases we've talked about so far. Typically within 1 to 2 months, you can get an approval for an O1. And as I said earlier, their dual intent is possible, meaning you can go for the green card here, sort of due to the nature of how an O1 operates. Okay, the next visa we want to talk about here is one that is not as common, but is one that is good to think about, particularly as sort of a gap fill option. If your intention to come to the United States on a long-term basis, J1 is not really designed for that, but it can be really good for people who need to buy time in order to do another process. So the J1 program is designed as a cultural exchange program. And the idea here is that in the United States, we send people to other countries, people from other countries send their people to the United States, and they're sort of exchanging culture. And so there's a whole bunch of different categories that qualify for a J1. For example, somebody coming as a nanny or an au pair can qualify for a J1. People coming as a camp counselor for the summer, something like that. Within the context of this audience, the ones that we see the most are interns and trainees. So people who need to come to the United States in order to be an intern, which means sort of a temporary work status, or a trainee, meaning that they're coming here to get some sort of training and then go back to their home country. Again, this is designed for people to come here, then to go back to their home country. So that's where at the bottom of the left column where it talks about the 2-year home residency requirement. Typically, the idea is that if you come here, you're going to go back to your home country for at least 2 years before you come back to the United States on a long-term basis. That doesn't always apply. It depends on your country of origin, because your country of origin will have a skills list. And if the skill that you're coming to the United States to gain is on that skills list, it means that it's something important to your country, and they want you to come back and use that within your own country for at least 2 years. There's also funding, if the government's funding it, or the funding source is something that may be a reason that it would attach that to your home residency requirement. There is a waiver process. So if you do come on a J1 and you are required to go back to your home country for 2 years, there is a waiver process where we can help you get a waiver to that requirement so that you can stay in the United States, not have to go back to your home country if you don't want to for 2 years. And so the intern, people that come as an intern and qualify as a J1 are people that are currently enrolled in a university program, or they've graduated and they're applying within 12 months of graduation. So that's how you qualify as an intern. A trainee is somebody who has a degree and at least 5 years of experience in their field, in their home country, and then they're coming to the United States for training. And the way this operates is that there are organizations that are pre-approved J1 sponsors. So if you came to me and we decided that you qualify for a J1, we have a J1 sponsor that we work with. That J1 sponsor would get the approval documents necessary, and then the company that's hiring you to do the work would be the host. They would be considered the host that's providing that experience to you. J1s are valid for up to 12 months initially, and they can be extended. So, but as I said, this is considered sort of a short-term kind of a gap fill option. If you were, say, let's say you were an F1 student, and then you ran out of options trying to apply for an H1-B, and you wanted to look at a J1 as a way to stay in the United States, it could work that way. Or if you don't see any other options to come here initially, and you want to get into the United States and then see if you can stay on a long-term basis, a J1 can operate well for that as well. So the E2 visa, this is the only non-immigrant visa, and this is the last one we're going to talk about before we move to what the green card process looks like. This is the only one that is a self-sponsor, kind of a quasi-self-sponsor option. The reason I say that is because you still do need a company in the mix here. You can't just sort of come over on your own. So there does need to be a company, but this is as close as we get to a non-immigrant option that enables you to sponsor yourself. So the first requirement is that you must be from a treaty country, and there's a list of countries that qualify for E1 or E2. E1 is people who are doing trade between their country and the United States. That typically doesn't apply to this group. More what we'd be looking for is E2, where you're an investor and you're looking to make an investment in the United States. This investment can be for an existing company where you are, so let's say you want to come and you want to purchase an existing company, you make that, and that is your investment. That is really good evidence of a qualifying investment for an E2. It can also be within the startup context. So let's say that you have an idea, you want to come to the United States to implement that idea, you're looking to invest a certain amount of money to get that startup going, you can do that as well. Of course, we all know, well, we may or may not be aware, but the statistics involved with buying an existing company that is successful and the chances of having that go well and continue to be a viable operation, the chances of being able to remain in E2 status are higher. If you do a startup, the fail rate of startups is really high. And if the company fails and your E2 is tied to that, then you would lose your status as well. So, I'm not a business advisor. I can't advise you on which way to go, but those are two options: looking to start up your own company or to purchase an existing company. And then the rest of these are definitions that I will explain on the next slide. The investment needs to be substantial. It can't be marginal. The company must be a real and operational company. You have to own a controlling interest in the company of at least 50%. And then, unlike the other statuses we've talked about, this is a pure non-immigrant intent status. So the idea is that you will be here in the United States while you're working in this company and getting it going and managing your investment, but that you're not going to go through and become a lawful permanent resident or get your green card. That's not to say that it's not possible to do that, but you can't do that directly from the E2. There's other ways to get around that. Okay, so now let me explain to you what these definitions mean. So if you're going to make an investment, the investment needs to be what is considered at risk. And what that means is that you have either spent the money, so you have made purchases already, and so therefore, if the company fails, then you lose your money. That's really the idea of at risk here. If the company fails, you stand to lose money. So a lot of times people say, well, I've set up a bank account here and I've put my investment in the bank account and I intend to use that money to make purchases and to get this company started. That alone is not enough. The government won't see that as having an investment at risk, because if the company fails, then you just withdraw your money from the bank account and you walk away. If you have it in an escrow account or it's committed in some other way, then that's good evidence that you've made that the money is at risk. The investment needs to be substantial. A lot of times the question comes up of how much do I need to invest? And there's not, unfortunately, a bright line rule on this. As with most immigration things, it's sort of up to us to make the argument, the legal argument, that the investment you've made qualifies. And what they'll be looking at is what type of business is it? What industry is it in? If it requires a lot of inventory, do you have that inventory? If it requires e-commerce, do you have a website, set up that enables you to transact your e-commerce business? So they'll be looking for those types of things, and have you spent sufficient amount? My personal opinion is if you spend at least $50,000, that's a good amount of money. Typically that would be sufficient. If you're spending less than that, that's not to say that you can't qualify, but we would need to make an argument about why or how that amount is going to be sufficient to get the company started. In terms of marginal, what they want to see is that this is going to be a viable company. It's going to have revenues. It's going to be operational. And one of the best pieces of evidence they look for is whether you're going to be able to create jobs. They figure if you're creating jobs, then you have a business that is a viable endeavor. So this is where we really recommend having a business plan to show, within the first year, we plan to hire 1 to 2 people or whatever it is. In year 2, we plan to hire 5 more, and show the government that that is the intent of this company is to grow, it's to create jobs, it's to have customers and be really sort of an ongoing viable business. Real and operational. So the things that they will look for here is that the things that you're buying, that you're using your investment dollars for, are things that they would anticipate a company would normally do. So do you have a lease for space? Do you have a website? Do you have, if your company needs inventory, do you have inventory? Do you have contracts in place? If licenses are necessary for the type of work you're doing, do you have those licenses? All of these sorts of things they'll be looking for that a standard business company would have to make sure that your company has it, so that it's a real company, it's an operational company. I already talked about non-immigrant intent. The one other thing I want to say is if you do buy an existing business, it should already have employees, at least 3 to 4 employees. It should also be profitable. If it's a company that's not profitable and you're thinking that you're going to turn it around, that's a hard application to get approved for an E2, because the government is saying, we don't think this is a real viable business. It already is not. You're saying you can turn it around. It's really hard to climb that hill and prove that you can turn it around. It's not to say that it's impossible, but it's a case that would be much more difficult. Okay, so with the remaining time I have, about 7 minutes, I'm going to walk through 2 green card options. And then, as I said before, I will go into the chat and answer questions that are in the chat for up to a half hour. And then if there are questions after that, you'll have my contact information, and feel free to reach out to me directly. I'm happy to talk with you about any questions you have. We will make this recording available to all attendees, as well as the slides. So one thing I want to show you before we talk about these 2 options is what the visa bulletin is. And I'm sorry, this says October. This is actually the February visa bulletin for this year. I forgot to update that to change that from October to February. So I apologize for that. But the dates there are accurate. So what this is for people who are applying for a green card, how long this sort of gives you a sense for how long you're going to have to wait to be able to get that green card. So if you see your country listed across the top there, that means that your country has a potential wait for the green card. If your country is not listed, then you fall into that second column there that says all chargeability areas except those listed. And then in that first column where it says first, second, third, those are the preference categories. So what you would do is you would say, okay, I'm in the second preference category for China, let's say, and that would be your date. So your date would be the 1st of June of 2020. So what that's saying to you is if you take the first step toward your green card process today, you're looking at roughly 3.5 years until you're going to have an immigrant visa number available to you. So it gives you a sense for how long you may need to wait for a green card. Now, if you look at the categories for our friends from India, the second and third preference categories, where it lists, a date in 2012, that, those individuals are going to have to wait, potentially 10 to 12 years before they're going to be able to apply for their green card. That's why, as I said early on, the H-1B is so desirable, because you can extend it indefinitely once the green card process is started. Most individuals qualify under the second or third preference category, which is why those dates tend to be longer, because they're oversubscribed. There's only a certain number of immigrant visa numbers available for each of the levels, first, second, or third preference. And so the second and third tend to get used up faster. These next two options I'm going to show you fall within the first and the second preference category. And so they are desirable in that way. And also they're desirable because they allow for self-sponsorship, meaning you don't have to have a company sponsoring you for these applications. You can do these on your own. So the first one is national interest. And basically what we're doing here is we're saying that the work that you're doing is within the national interest of the United States, and therefore we can have an advantageous green card process for you. Most green card processes require that we go through the Department of Labor to show that the job that you're taking is not displacing U.S. workers, and there's a whole process around that. This option, you basically get to skip that, because what we're saying is the work they're doing is so important that we shouldn't even make them go through the process of showing that they're not displacing U.S. workers. So the four main criteria are here: substantial merit, national interest, well-positioned, and then that on balance, it's beneficial to waive that requirement of showing that you're not displacing U.S. workers. So substantial merit, again, we're talking about creating U.S. jobs. That's something that they often want to see in these applications. And so the fields that we typically see that people qualify for national interest waiver are within medical research, homeland security, renewable energy, education, and then more recently, the financial system. As we've seen, there's been a lot of things going on within the banking industry and in finance within the United States. So if you're working on something within that endeavor right now, it's considered within the national interest. There are other fields, so this is not an exhaustive list, but these are the ones that we typically see. And then, of course, national interest. So this is something where we can say this is going to benefit a lot of people. So that's why medical often comes up, because, if you're doing research to help cure cancer or, some other disease, we've seen a lot recently on COVID-19 and vaccinations. If you're doing something like that, then it's easy to make an argument that it's in the national interest of the United States that you come here and continue your work here. Being well positioned to carry out the endeavor. So they'll be looking, if you are employed by a U.S. employer, then that's good evidence of this, because it shows that you're well positioned, you're going to be hired, you're going to be paid to do your work. But even if you're not, do you have investors? Do you have patents? Do you have contracts with companies here to do your work? Those are things to show that you're not just going to come here and then not do it. You're going to come here and actually do the work that the government anticipates that you'll do. And then I've already talked about four, that on balance, it makes sense to have you sort of go through a faster green card process. Okay, the last one we're going to talk about here is EB1 for extraordinary ability. You'll see that this slide looks remarkably similar to the O1 slide, and that's because the criteria for qualifying are essentially exactly the same. So that's why I said if you qualify for an O1, then your path to the green card is pretty quick, because you would likely apply for an EB1 status, green card status. And I won't go through each of these criteria again, because I did that under the O1. If you missed that, feel free to reach out to me and I can talk to you about what these mean. And again, you'll get a copy of these slides, so you'll have this list that you can look at. But I want to go back and show you here this visa bulletin. Again, this is February, not October. So if you look at that first row, where it says first, if you're from any country that's not listed there, that C means current. So if you're from Germany, let's say, and you qualify for the EB1 extraordinary ability green card process, that means that there is an immigrant visa number available to you now. You can apply for your green card now. There's no wait involved. And in China, there's virtually no wait there. India, there's a couple of years. So that's why the first preference category is so desirable, because the wait is much shorter. Now, the national interest waiver one that we talked about, that falls into the second preference category. So if you're from a country not listed there, again, the wait is almost negligible, because by the time we apply, and then we get to the green card application, which comes next, chances are that date's going to be either there or pretty close. If you're from another country like China, again, it might make sense to do the national interest waiver. Now, if you're from India, a lot of times people ask, does it make sense? Well, if you look at the date there, the wait is still really long. And so typically for people from India, I would say to go through the standard green card process, because going through the national interest waiver, the chances of success are lower, the costs are high, and the wait is going to be similar anyway. So it might not make sense if you're from India to do a national interest waiver, but it would make sense to do an extraordinary ability because you'd be in the first preference category. So just something to consider there. Okay, I'm going to go ahead and skip these last few slides. Well, let me talk about them really quickly, and then we'll get to the questions. And again, these slides will be made available to you, so you can look at them after. So I'm going to go kind of quickly through them. But this slide here talks about how long it takes. The PP stands for premium processing. If it's in green, that means you can pay the extra $2,500 to get the case premium processed. If it's in red, that means premium processing is not available. So you're stuck with the stated processing time. And again, as you may remember, premium processing is a 15-day turnaround. So if you file a case with premium processing, the government has 15 days to get back to you. In terms of cost, this is another reference slide. You can see kind of what the costs are. That variation is based on what the law firm is going to charge you to do it, whether you have family members you're going to include in the process, whether there's things like a business plan you would need to pay for, or translations of documents, or an education evaluation. So there's some variation there. The validity, this will show you how long each of these statuses is valid for. And with that, here's my contact information. So feel free to reach out to me if I'm not able to get to your question, but I'm going to go through the chat now, and I'll read aloud the question and then I'll answer it for you. Okay, the first question here says, my wife has a bachelor's degree and a master's degree in engineering. She is working full-time as a pharmacy technician in Canada. She's getting an offer from a US dental office for dental office manager. She will be able to apply for that offer, and which visa is she eligible for? So she has a bachelor's degree, professional position in engineering, working as a pharmacy technician. So one of the things we would need to know is whether the working as in a dental office is aligned with her degree field. One of the problems we run into is where a person has a background in a certain field, and then they take a job in a different field, or sort of an unrelated field. A lot of times we won't be able to show that there is a connection between the two. And if we can't do that, then the person won't qualify. So that would be the first step. The second step I would ask is the country that she's from. So it says here Canada. I don't know if she's just a resident of Canada or is from Canada. She's actually a Canadian citizen, then an option could be a TN or trade NAFTA um, visa, and this is specific to people from Canada and Mexico, and there are certain fields that are allowed, so that could be an option there. Um, I would need a little more information to answer this fully, but those are some things to be thinking about there. The next one says, I am a Canadian citizen. Am I eligible for H-1B visa or only TN visa is the option? Yeah, so if you're Canadian, you can apply for a TN. Obviously, as I said before, you can also qualify for an H-1B. You could qualify for an L1. So being Canadian doesn't mean that you have to apply for a TN. The other options are open to you as well. I am a 5-year experienced software engineer and working professional. I am a married person. I am looking to get full-time employment in the US. Can you please guide me uh, the enter pathway I need to follow and all the reference points I need to look for? So somebody who has this level of experience, I would say if you're not in currently in the United States, your options would be to one, find a company that would sponsor your H-1B. And if they'll do that now and you get into this year's lottery, then if you're selected, then that H-1B would become valid on October 1st. And then you would be able to apply for an H-1B visa in your home country, enter the United States, and begin working with your H-1B. Again, there are country-specific work visa options, like we talked about Canada and Mexico. There's also one for people from Singapore, one for people from Chile, and one for people from Australia. So if you're from any of those countries, there's a specific work visa. If you're not, then we'd probably be looking at the H-1B. Now, for this individual, if they are working for a company outside of the United States, and if that company has a US operation, you could look at an L1 also, where you would qualify as an intra-company transfer. So you would transfer from your company's foreign office to the US office, and then you would be able to work in L1 status. Okay, 3 quick questions. I have been told generic sales roles are not eligible for H-1B. Is that true? Um, I hate to say yes. Um, but yeah, if you're saying a generic sales role, typically that's not sufficient for an H-1B. However, if you have an engineering degree and you're going into sales, on some equipment, where your field is related and you're in the sales department there, and your engineering background is critical for that sales role, then you can qualify. But if you don't have a professional degree and that is required for your sales position, then typically, yes, those sales positions don't qualify for H-1B. In your experience, as the degree requirement is most important for H-1B, what kind of roles could someone with a master's in management pursue? This is another tough one, and it's such a bad design, because somebody who gets a master's degree in business or an MBA, that's considered a very generic type of degree, and it's pretty hard actually to qualify for an H-1B as somebody with an MBA, which is crazy. But there are roles that can qualify where if you had an emphasis within your master's degree in finance, let's say, as an example, or commerce, those are areas where you potentially can qualify for an H-1B. So it's more difficult because, again, from the government's perspective, a master's in business is considered, not as focused as they like to see. But sometimes within MBA programs, there is that kind of focus. So we would need to kind of dig in and look at the specifics of the degree. Next question. Any recommendations on how to convince a startup to sponsor H-1B and what kind of problems they might run into as they are doing the process for the first time without a blanket petition. Yeah, so startup companies, well, there's a couple of things that they have issues with. One is often they've never done it before, so it seems daunting because it's unknown. They don't know how to do it. The other thing is the cost, and looking at paying for an H1B, where sometimes the cost can be anywhere from five to $7,000 total. A lot of times, startup companies are like, we don't have that kind of money. We don't want to spend money on this process. However, there are a lot of startups out there that do understand that in order to get the right person for the position, often they need to go outside of the United States to get that skill set, and they are willing to pay, especially if they've raised money and they have money for these types of things, then you can get them to understand how paying for that cost to get the right candidate is the right thing for them to do. So that's the kind of thing where a lot of times I will set up a call with the stakeholders at the company and kind of walk them through what the process looks like, walk them through what the costs are. And a lot of times once they have that conversation and understand what it entails, then they're much more willing to do the process. So that's certainly an option we could look at doing. Are there any short-term work visas coming to the US for 2 to 3 years? Yes, any of those work statuses I talked about can be short-term. So even if you get an H1B, but you only want to be here for a couple of years, you can certainly do that. You're not required to stay for the full time. Or if you come in on an L1 as an intercompany transfer, you could stay for a couple of years and go home. So any of those visas we talked about could meet this requirement. You're not required to stay the whole time. You can leave whenever you want to. I'm living outside the US. However, I have a US C Corp in the US. Would I qualify for E2, assuming that I meet the qualifications you outlined in the definition? Yes, you could. One of the things that they want to see is that it's a new endeavor. And so we would need to look at how long the company has been in existence. And if it's fairly recent, then yes, we would want to put together a business plan to say, okay, the entity is now set up. We're going to be doing, setting up the website. We're going to be getting a lease. We're going to be getting contracts in place. These are kind of the next steps. Then yes, an E2 could be a good option there. Next question says, after our US visa is approved, how many months can we stay in our own country before we lose the visa? I mean, 6 months is too long to spend outside the US before we first enter the US. So if you get, let's say, well, any of these statuses you get approved through USCIS, then you take that approval to a US consular post in your home country. You apply for the visa that enables you to enter the United States. And then the question here is, how long can we hold that visa without using it and not lose it? The answer is, as long as the visa is valid and as long as the underlying approval is valid, you can come in anytime. So if the visa is valid for a year and the approval, let's say, is valid for 3 years, and if you want to wait 6 months, that's totally fine. As long as what we may need to do is get a new letter from the company that you're coming to work for, just to indicate that the job is still open and still available to you, because that could be a problem if you go for the application and they say, oh, this job offer is 6 months old. How do I know that you still have a job offer? So we'd want to get an updated company letter, but yeah, you could use that visa even if it's 6 months old. Let's see, what is the best strategy for an entrepreneur or a solopreneur? I haven't heard that before. That's cool. Let's say I have a history of establishing successful companies which still exist and have employees. Currently have a company but don't have employees. I have inventory, a website, and a big portfolio. And I would like to move my services to the US, i.e., shut down my company in the current country and open it in the US. Unfortunately, my clients are local, so that won't transfer. In addition, I'm currently an immigrant, but I have only moved within the EU. Okay, so there would be a couple of options to look at. The first I would mention is the L1. Now, So the L1 is that transfer where you're transferring from the foreign company to the United States. In this scenario, we would be looking at a new office L1 because it's not an existing operation right now. You would be setting it up. And so that initial application would be valid for 1 year, where USCIS would say, okay, you've told us this is what you're going to do. We're going to give you a year to do it. Then at the end of that year, we would need to file an extension to say, okay, this is what we said we were going to do. This is what we actually did. Give me the extension. And if you're successful, then you would be able to stay here on an L1. Now, in this scenario, the L1 might not be best because you're saying that you want to close that foreign office. So as long as the foreign office is open, you can continue to qualify for the L1. If you close that foreign office, then that relationship between the US and the foreign entity goes away, and the L1, it would no longer be valid. So if you are looking to close that foreign office, then I would say your better option would probably be to look at an E2 as an investor, that you're coming in, you have a viable operation in your home country. We would use that as a blueprint for how you would set up your US company, and that would be really solid evidence that you're going to do the same thing just now in the United States. And I think an E2 could be a good option for you. I'm a Nigerian international student in England. I have just graduated with a master's in science from data science. Which option of visa am I eligible for? Um, Probably your best option is going to be an H1B, finding a company in the United States that'll sponsor your H1B. You could come to the United States as a student and get an F1 visa. Um, but you would probably be wanting to go for a PhD or something higher. I don't know if that's something you would want to do. If you did, F1 would be great. If you don't, if you want to get a job now, then your best option would be to look at an H1B. Now, if you do apply for an H1B and you're not selected, I would say that your next best option might be to find a company in England that has an operation in the United States, and you would need to work for that English company for at least 1 year. But then after you do, they could transfer you to the United States in an L1 status. So those would be a couple of options you could look at. As an industrial engineer from Chile, working in an innovation food logistics and distribution startup as a co-founder, what would be the right visa to get for developing this endeavor in Santa Clara County, California? So the country of Chile is one of those countries that has specific work visa options, and it's actually called the H1B1, which is confusing because it kind of operates like a standard H1B, but it's different for a number of reasons. But if you're from Chile, you can qualify for an H1B1. Now, what we would need to make sure is, and we talked about this earlier, is that your education background aligns with the work that you're going to be doing in the United States. So if you have a degree in finance and you're coming to do food logistics, that might not work. But if you do have a degree that's related to the logistics and distribution, and it's at least a bachelor's degree, and then you're coming here to do that, then that H1B1 would be a great option for you. Let's see, where will this visa and slides be available? Very enlightening, thank you. We will email these out to everybody, so you'll get a link for the video, which will be posted on YouTube, and then you will get a copy of the slides as well to your email. Is TN visa holder gets green card? So TN status is considered a pure non-immigrant intent status. And so I had mentioned earlier how when you are in a dual intent status like H1B and L1, the process is very smooth to a green card. Now, if you're in a pure non-immigrant intent status, that's not to say you can't go for the green card, but you can't do both at the same time. Meaning, let's say you're in H1B, and so you have that process going along, you start the green card process, those processes can go together at the same time. If you're in a TN status and you start the green card process, that green card process will nullify the TN because there's a conflict of intent there. So the way you would move from a TN to a green card is basically you would be in a position where you would we would get you far enough into the green card process to where you no longer need the TN. So you would essentially switch. So you would be in TN status, you would be working based on the TN. Then we would get that green card process to a point where you could work based on the green card process and you don't need the TN anymore. So once that goes away, you're still able to stay here based on the green card process. So I've kind of oversimplified it, but the short answer is yes, you can go from a TN to a green card. It's just it takes more planning and to get you there. Okay, the next question says, when job ads ask, are you authorized to work in the US and do you or will you need sponsorship? Is there a separate authorization to work process? I'm an EU citizen, not a US right now. Yeah, those are the questions that there are discrimination laws in the United States against, country of origin. And so they need to be companies need to be careful about how they ask this question. My advice is always, if you're asked this question, just be straightforward on what your status is and what you're looking to do. Because what you don't want to do is have a company not understand what your status is, bring you in, and then realize you require these sponsorships and have it not work out. The better way to do it is, if it's a company that's not willing to do that, and you tell them I need sponsorship and they say, well, we don't do that. It's better to know that up front and to find a company that does have a process in place to sponsor individuals from other companies or from other countries. And so my advice is always just answer those questions very straightforward, open up and tell them what your status is, if you're in the United States or if you're not, that you will require sponsorship, and just make that clear to them. I'm aged 53 with 3 masters, agile management certification done, doing data analytics certification. Can I be prospective candidate for EB2? Yeah, so EB2 does not have any specific background requirements. It's really more about the investment that you're going to be making and that you're going to meet all those other criteria, like you're going to own at least 50% of the company. You're going to be able to show that the company is a viable operation. Hopefully you're going to be creating jobs. So that's really what they're focused on, not so much your background and your education level, but more what the investment is going to be and whether you're likely to be able to succeed. Okay, that's the last question in the chat. So we will go ahead and end this recording now. And as I said before, you have my contact information. If you have additional questions, please reach out. Thank you for attending. We'll see you next time.